Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name remains Aaron Asiedu-Antwi. Today we are looking at the constitutionality of the suspension of the Chief Justice. But before that, this video is proudly sponsored by Vian's Groceries. They are located at Parakou Link here in Dome. You can contact them. Their numbers are on the screen. You can just contact them wherever you are in Accra. They should be able to deliver any grocery you want. Also proudly sponsored by Nkrumah, any kind of food. You know Accra life. You'll be going to work. You'll be going to you'll be attending to a lot of activities. You need them to prepare your stew, your food, your jollof, everything. Contact them and they should be able to deliver the quantity you want and also the taste that you prefer. Today we are looking at the constitutionality of the suspension of the Chief Justice. I'm talking about Madam Gertrude Araba-Isaba Tokono. I started this conversation around Article 146 with my brother Julius Kwame Anthony. Myself, I did an editorial on why I believe the suspension is unconstitutional. But today, I'm having a fine gentleman, Mr. Ebenezer Sefakisi. Welcome to the Law Lab.
Thank you very much for having me.
So Mr. Kisi is my president during our LLB days, LSA president. I campaigned against his candidature, but today he's on the Law Lab. He believes otherwise in my position, that he believes that the suspension is constitutional. But I would first pick his initial thoughts and we'll look at why he believes the suspension of the Chief Justice is constitutional. So, Kisi, welcome again.
Thank you very much. Thank you very much. And you are doing a great job with the Law Lab.
Thank you so much.
Commend you.
Thank you so much.
For this wonderful work.
Thank you. Yeah. Thank you. So, quick one. Suspension of the Chief Justice on the back of some 3 petitions that was brought before the President of Ghana, forwarded same to the Council of State, back establishing a prima facie case, suspending Madam Araba-Isaba Tokono. Ghana Bar Association has taken a strong position that they believe the suspension is unconstitutional. What is your initial thought before we look at the constitutionality of the suspension?
Well, I think, so far, for me, the process has just followed the procedure as outlined in Article 146, and I'll beg to differ, from the position of Ghana Bar Association and from your own position as to in relation to the suspension, whether it's unconstitutional. I believe it's constitutional, rightly in accordance with the dictate of Article 146. So that will be my initial comment. Yeah.
Okay, so I think I need to set this out clearly. I have no problem with the process, but for the suspension, that is where I have an issue. Good. So let's look at Article 146 of our Constitution. I think Julius has taken us through all the procedures, so it is clear. But let's look at Article 146, Clause 10. It says, where a petition has been referred to a committee under this article, the President may, paragraph A, in the case of the Chief Justice, acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the Chief Justice. The word may rings a bell. It is a discretionary power. And discretionary powers are regulated by Article 296 of our Constitution. The reason is very simple. You know, Lord Acton once said, power corrupts and absolute power corrupts absolutely. So if you give someone a discretion, the person has the power to either act or not to act. You get it? And so Article 296 provides a fetter on how you exercise your discretionary power. In 296C says that you need either a constitutional instrument or a statutory instrument to regulate the discretionary power. I believe that when we have the CI or the statutory instrument in place, we get to know that if it is CJ Kisi, this is what he does. He is likely to be suspended. If it is CJ Aaron, well, I don't want to be on the bench. I need to issue that disclaimer. This is what he would be suspended on, so that we wouldn't have any arbitrary way of suspending. And you think the CI is not necessary, or why do you say the process has been constitutional when there is no CI in place when Madam Araba Tokono was suspended?
Okay, very well. Thank you so much. So I would like us to look at 296 in terms of the clear provisions, just to, refresh our memory.
Very well.
So 296 says that so it says that when this constitution or any other law, discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. C, that's where your emphasis is.
I didn't circle it.
Exactly. So where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or statutory instruments regulations that are not inconsistent with the provisions of this constitution or that other law to govern the exercise of that discretionary power. Okay. So 296 persons, students of law, you realize that anytime there's a constitutional issue, it's interpreted by the Supreme Court. 296 has been interpreted by several decisions, but I want to look at just two of them, Ransford France, and also in the case of Eliklim Agbamava Alfred, Tuyayeboa, and Asante Bedietu versus
Nana Asante Bedietu.
Nana Asante Bedietu.
Asante MB.
Nana Bedietu Asante. That's very wrong. So you see, this provision came up in Ransford France case, and I believe that you've discussed that.
I've read it.
Exactly.
Yes.
And the provision is very clear that, in the exercise of the president's power or authority, there are so many discretions that the president will exercise. And that if you are supposed to hold the president to the strict dictates of 296C, what will be that is going to lead to what he called
it's going to ground the government.
Exactly.
That is what
it will lead to a nuclear meltdown of the whole state. And even decisions that have been taken prior will be invalidated, because when there's a breach of constitution, it goes to the roots. Wherever you started any act, it will be invalidated. So clearly he saw that problem, and he said that, okay, 296 should not be applicable in every and any situation. However, he stated clearly that this provision should be applicable when there's anything called adjudication. When the president or any person exercising any adjudicating authority, and the person is not a judge or a judicial officer, then this provision should kick in. However, he also stated that even when there's a breach of 296C, it's not fatal. We have to look at it case by case and look at that specific instance to see whether in this instance should we invalidate what has been done or not to be done. So we have to keep that in mind clearly.
So wait on Ransford France.
Okay.
I've read it.
Okay.
That Eba JSC, as he then was, relies on the reasoning of a Kufuado JSC in the case of Captain versus the Republic.
Precisely.
And he quoted with approval that in a quasi-judicial process, where you are adjudicating, you need a CI. You agree to that?
Perfect. I mean, that was right.
That was the exception that was
decision.
created.
Yes.
Good.
Yes.
And you believe that in this instance, it is not a quasi-judicial process?
Okay, so in this process, 146, en bloc, if you look at it wholly, you might come to the conclusion that it is quasi-judicial.
Don't say mind, it is.
No, I'm saying that yes, you will come to that. That's what I'm saying, that if you are looking at it in its entirety. However, what we have to do is to unpack it. Look at the whole provisions, 146 down to 10, whatever, and look at the process. There are some that is not adjudicatory. There are some that is not. And clearly, if you say anything is adjudicatory, it's not just a decision making. It's the process to adjudicate on something. And that's why in the wisdom of the framers, it says that a judge or a judicial officer, what is a judge or a judicial officer supposed to do? If you have any case, they'll bring the two parties together. You narrate your story. Someone has an opportunity to cross-examine what you've said. It moves to the other party. The other party does same, subject to cross-examination, be it criminal or civil. Then you look at the standard of proof amongst others. So this is what a judge will do. This is what a judicial officer will do. So it says that if another person is doing the same process, even though the person is not a judge, the person is not a judicial officer, so it can be in your workplace. there can be a disciplinary committee. They will sit and be doing what a judge will do. So then it becomes quasi-judicial because you are not in the proper context of.
Are you in any way suggesting that adjudication is only when two parties are before you and you are making a decision? Is that what you are trying to mean?
Okay, so in this part, so we are looking at 146.
Yes.
It is.
Let's look at the word adjudication.
Yes.
If we understand the word adjudication, we can situate it in 146 to determine whether the president suspending is adjudicating or not. So the word adjudicating, are you in any way suggesting that it is only when two parties are before you and you making a determination on their matter, that is when you are adjudicating?
No, so you know clearly that even in law, you can adjudicate when there's even one party alone. But the process, what that means is that you, the party, you are going to listen to one party. Whoever is exercising the authority, you are going to look at the document. You are going to rely on certain rules, certain regulation to come to that conclusion. So yes, it might not necessarily be a party, but my focus is the process. You are going to conduct a particular process. So if you do that, then you are adjudicating.
Good.
You understand? So that's why I'm saying that let's situate this 296C in the context of 146. So I say...
Before you situate,
okay,
the Black's Laws Dictionary defines adjudication to include a decision, a reasoning, a ruling. So as you rightly put it, even when one party is before you on an ex parte motion, you still adjudicate.
Yes,
you get it.
Correct.
Now let's break Article 146 into three.
Precisely.
The prima facie stage, the suspension stage, and the committee stage. You agree with me that the prima facie stage, you are adjudicating?
Yes. On that score, you are. Yes.
On the suspension stage, you are adjudicating?
You are not.
Why?
Okay. So the reason why I say that when it comes to the suspension, you are not is that the provision is very clear. 14610. Let's go back to it. So 146 says 10.
Page 105.
Yes. Where a petition has been referred to a committee under this article, the president may, in the case of a chief justice, acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the chief justice. For this one, he's not engaging in, the president is not engaging in any adjudication, because immediately he acts, he's acting on the advice of the Council of State.
Mr. President,
he's acting on the advice of the Council of State.
Let me still call you my president, because once a president.
That's fine.
You agree with me that it is settled law in Ghana Bar Association and Attorney General under the same president, President Mahama, on whether or not to appoint Justice Mahafosao and other justices to the Supreme Court. The court ruled that the advice from the Council of State is not binding. You agree with me?
That is correct.
So if something is not binding and you bring it to me, I have to take a decision as to whether I will accept it or not because it's not binding.
Exactly. I agree.
So when I'm taking a decision and the Black's Laws Dictionary says that adjudication should include decision, reasoning, ruling, am I not adjudicating?
You are not. That's what I'm saying that. You see,
you've taken a decision.
No, so I'm coming. In the wisdom of France, that the bar was very clear that, you know what, there are several decisions that the president will take. You understand? And in any case, if you look at this, it's saying in acting in accordance with the advice of the Council of State. It's not on the advice. And words, you know, in the Constitution is very, you cannot ascribe, even though GBA will tell you that it's on the advice will be, I mean, you are not bound by the advice. This one, immediately he acts in accordance with the advice. You see?
What's the difference between on and with?
You see, in the case of appointing judges, the Judicial Council would now go and make a proposal to the president that we want you guys to pick maybe 5 people.
Yes.
And that was the, government of that particular case that he was supposed to pick those who have been recommended, but he chose some and left some. So there, the GBA contention was that you've breached the Constitution because when they provide you en bloc, take everybody. You don't have to skip anybody. You understand? Then the court came to the conclusion that, you know what, if you do that, I always say that, you see, anytime we are reading a case, we take the whole thing, you might miss the point. It's the ratio, the reasoning is what...
I agree with you. The ratio
the judges said that if you do that, then in effect, the president is not appointing judges. Then you, the Judicial Council, you are appointing because you've tied his hands. Any person you put on the list, he has to appoint them. And the court said in that case that on the advice of your the Judicial Council, the president is not bound by it. He has the luxury. So on the advice, yes,
advice is not binding, or on advice is not binding.
So I'm saying that on the advice of the, because they advise, that's what the provision says.
No, I'm saying
that's what was contested,
Mr. President.
Yes,
I'm saying that in the third case, the Supreme Court reasoned that the word advice is not binding, because if you read the ruling of the court, he included whether the advice is coming from Council of State, Judicial Council. In fact, the only caveat the court said that the list should first come from the Judicial Council.
Precisely.
And when it comes, the president is not bound to choose any of them or take them en bloc. Okay. He has that discretion to choose some and leave some.
Very well.
Yes.
Very well.
So did the court reason that the word advice is not binding, or on advice it's not binding? I want that clarity.
No, that's what I'm saying. You see, the decision wasn't in a vacuum. We look at the clear provision which GBA contested.
That's what I'm saying. Article 144.
Yes, that's what I'm saying.
Let me read it.
Yes, read.
The other Supreme Court justices shall be appointed by the president, acting on the advice
precisely
of the Judicial Council,
precisely
in consultation with the Council of State and with approval of Parliament. Exactly. For the last time on this question,
exactly,
are you saying that the court reason that it is advice that is not binding, or the court reason that on the advice that is not binding?
So my point is that it was a particular provision that was challenged. The Supreme Court was making an interpretation on that particular provision, and that provision is on the advice. So it cannot be that they are taking an advice and it will be outside the provision. They cannot interpret what has not been brought before
today,
them.
With accordance with advice of the Council of State, should be binding on the president.
Yes, it should be under 146. I mean, that's my contention. Under 14610, it should be binding.
So what will be the effect of the may?
So the may is that
if the advice is binding and the president doesn't want to suspend, then it renders may ineffective.
No, that's why I'm saying that this is a different provision. It says that the president may. So if the president wants to suspend, he has to go to the Council of State for that advice, and the advice that they give is binding on him. So the discretion,
144 advice of Council of State is not binding, but 146 advice of Council of State.
No, so I'm saying that in this case, the may here is that the president may.
Okay.
In the case of acting, so he may choose to go to the Council of State that will give me advice whether the CJ should be suspended. He may choose not to go. So the may is as to whether he will go or not to go.
But when he goes, he is bound by it.
Yes, he cannot go contrary to the advice under 10A. He cannot. I mean, that's my contention. The discretion here is whether to go to them or not to go to them. So he may choose, well, in my case, I don't want to engage in anything, whether suspend or not to suspend. I'll not come to you. He cannot be forced to go to the Council of State. The only may here is discretion, whether should I go to the Council of State or not to go. And when he chooses to go, he cannot go contrary to the decision that the Council of State has given him. I mean, that's my contention.
Okay. So let's look at the Elikplim Agbamava case too.
Exactly. So in Elikplim Agbamava, this same issue 296C came to play. And for me, that is the case that even settles it. Even if some people are making the argument whether runs for France should apply or not. Even if you don't want to apply that, Elikplim Agbamava, Judge Bennett settled 296C. And in that case, he made the reference even to Ransford France. We said that he's not in any way trying to say that Ransford France should not apply. But then he went back to A and B and Article 296 to say that there's a reason, there's a rationale, going back to the spirit, to go and understand why we have 296A and B. As you rightly said, is to guide against the abuse, arbitrariness of power. So what then he said in that particular case is that, you know what, the Constitution itself has an inbuilt mechanism where this A and B will be satisfied. So when the Constitution, anybody acting on advice or any exercise of discretionary power, and there's a procedure in the Constitution to guide against that discretionary power, then the person does not need to comply with 296C. You understand? He went further to say that, you know what, because at the end of the day, if you say someone is abusing his power, his authority, if I solve that, there's no issue again. You only go to court when you claim that someone has exercised discretionary power and the person has abused those provisions. Judge Benny said that you also went back to the main principle which Duce said, that a man said in France for France. His position was that, you know what, the government will take decisions any day, anytime. So this, we have to be careful about 296, because what then will be that there will be a situation that we need the executive to take a quick decision, and they will be bound by 296. And now you are going to raise either a statutory issue, go and drop it in Parliament, 21 working days for it to.
That is settled by Ransford France.
That's what I'm saying. That in that case, when you are doing any, even if you want to adjudicate on any matter, even adjudication, there are times that you have to take a quick decision. But then the point again, Bennett said that at the end of the day, you want to satisfy A and B. Has the person satisfied it? If you look at the provision and the Constitution has provided a procedure for it, then you have to dispense with C, because there's no need for C again. And he clearly said that anytime any person, any authority is acting on the advice, either be it the police council, the council of state, any other person, what becomes of the person is that they are taking that power out of you so that you don't abuse it. So that if you are abusing that power, that other arm or that other authority or body you are supposed to act with will be a factor to that particular provision. So if you do that, then clearly you are not bound by 296C. So again, my point is that even if Ransford France, I mean, some legal scholars have their own position, which I have my position.
But technically, JSC Benin did not depart from Ransford France. They are
exactly. That's what I'm saying. That in any case, if you agree with that, that they are, when it comes to adjudication, now the contention is whether 146 is adjudicatory. I'm saying granted, we even granted. Let's say what the president is adjudicatory. Now, Benny has said that if any person who is supposed to exercise any discretionary power acts in accordance with any other body, that body will serve as a fetter on that authority or power, so that the essence of A and B is that you don't abuse your power has been satisfied, and you can dispense with 29C. So in that case, 29C in this instance, where 146 says you have to act in accordance with the Council of State, he has satisfied that particular provision, so he does not need to come back to 296C again. You understand?
I get you. So clearly, what you are trying to tell all of us is that per what Benny JSC said in Elikli Mabawanva and others' case, you are only telling us that acting on advice in 144 clause 2 will not necessarily be binding on the president, but acting in accordance should be binding, because the said body you are acting in accordance serves as a fetter which will dispense 296C. Is that okay?
Exactly. Rightly so.
Well, fair argument.
Rightly so.
But today, on advice is not binding. In accordance with is binding.
Wow. No, you don't get. No, let me put it this way.
Acting on the advice of the Judicial Council is also a body which will also serve as a fetter on the abuse of discretionary power. You agree or not?
You see, we have to. That's why I keep saying that. Let me restate the point again. If you look at 14610, the discretion is about the president going or not going.
Okay.
On the appointment of judges, is the president appointing them or not appointing the list that has been brought to him? It's not about him whether he chooses to go or not to go. The Judicial Council will bring it to you anyways. So that one, he doesn't have a power whether they should bring it or not to bring it.
Okay.
You understand? And that's why they say that if they bring that to you, then he is rather going to exercise a discretion to know which one you have to pick. But when it comes to 14610, it's about whether he has to go to them or not to go to them. But if you go to them, then you are bound by it. And like I rightly said, Benny rightly said that if you do that, you've complied with 296, and you don't have to, comply with 296C again. You understand? In any case, even under even the committee, some have made the argument that when the committee says, then it's going to be adjudicatory proper. And based on that, they are supposed to come up with a regulation, which is actually not even true, because the provision of 296 is the committee is supposed to be chaired by a Supreme Court judge. 2 justices are supposed. So anytime they are in there, then you dispense with C, because they are going to ensure. And I think the reasoning of the framers is that when you have a judge sitting on this kind of panels or exercising that power, by their training and learning, they are supposed to abide by, not to abuse their power, abide by natural justice amongst the likes. So even the committee, as people have even claimed, for me, the committee does not even need 296C because 2 justices of the Supreme Court are going to be there and it's supposed to be chaired by a justice. So, I mean, clearly, they are not bound by it.
Point fairly made. Let me ask you this. The Chief Justice is appointed by the President, who is elected by all of us, the President.
Very well.
Appoints the Chief Justice. The Chief Justice receives blessings from the people's representative, that is Parliament, meaning the Chief Justice becomes the people's Chief Justice. You agree with me?
I mean, very well. That's correct.
Article 125 of our Constitution clearly tells all of us that justice emanates from the people, and it is exercised for and on behalf of the people by the judiciary. So justice itself, it's coming from we, the ordinary people.
That is so.
So if we hire someone to head an arm of government, you think the President, who is also being hired by us to be a head of an arm of government, can wake up in the morning together with the Council of State, which we did not vote for, the Council of State, we did not vote for them, go and suspend someone without consulting us as the people? You don't think that the CI, getting a CI from Parliament, the representative of the people, would rather involve us in getting to know that the one we hide, the People's Chief Justice, probably has conducted him or herself in certain way, and as such can be suspended? The question is very simple. You think the People's Chief Justice can be suspended without consulting the people?
Well, I agree that, I mean, to a point, that when it comes to, at least all of us, we are awake now to Article 146. I believe when we were all studying the judiciary, so they have security of tenure, they can't remove, but now there's a wake-up call like, woo, if you look at the provision, I think it's one of the easiest things for any executive to get rid of the CJ. So what that means is that we have to look at the provisions again.
It calls for a constitutional amendment.
If there's any amendment.
So you agree?
And I'm happy, and I'm happy now Professor Kwesi Prempeh is working on it.
Let's make
something
a paper
that they
on
have
that.
to. I honestly, I don't believe that we should be able to let one arm take off the other. But then, I mean, separation of powers by embedded also is checks and balances. So then the point will be who watches the watchman, as we say, who will be there to check the judiciary, you understand? But you see, funny enough, I did some study, about the first constitution, 1960, 69, 79, looking at the same provision. You know, Nkrumah had his way under Article 45 of the 1960 Constitution.
Talking of Nkrumah, you know, it led to the 1963 Treason Tribunal of Adam Afiu,
very well,
which led to Chief Justice Akukosa, Akufo-Addo, William Van Leer being sacked. It is why we are here.
That is true. And I agree.
And
that's what I'm saying.
It is why I believe that you need a CI to sack to suspend the Chief Justice. Because if you don't get the CI, it means you have not involved the people in the process.
That's what I'm saying, that we should go back to the history. Yes, 1960 Constitution gave the president the power to dismiss judges when he wants to, and with 2/3 majority of parliament. I mean, you all know that CPP predominantly were made up of.
It was a one-party.
That's what I'm saying, that for them. So he easily was able to achieve that. Then in the 69 Constitution, then a kind of 146 procedure was inserted. But what I find curious was that when it was inserted, you realize that the committee that was supposed to be set up was supposed to be set up by 3 justices of the Supreme Court and 2 other persons who are not judges, lawyers, and not members. Yes, for the Chief Justice. Same was repeated in 1979. 3 Supreme Court justices and 2 other persons. But when it comes to the 1992, you realize that it was just 2 and 3, which I think that, for me, I don't believe in the wisdom of that, because a Chief Justice, like we rightly said, is a third arm of government. And if you need somebody to take that person, suspend that person, or, remove such a person from office, he should be tried by his peers. And persons sitting in the Supreme Court should be persons that would be fair in the kind of trial done, given 3 other persons who are supposed to be appointed by the executive. So I think that is a wake-up call for us to look at this provision again. I don't believe in removing the various arms of government. I believe that we have to have a stable arm of government for them to perform their work. That is not to say that we should take away the scrutiny or the accountability of another arm.
I agree with you.
It should also work. But then in this instance, unfortunately, this is what the Constitution is providing. And the president will just go by this Constitution only. But I think that if you are able to look at this provision, we will get to a stage whereby we don't get the executive trying to overreach, as it were, trying to take off one arm of government or so. So, I mean, honestly, this is my position on this procedure. But then, like I rightly said, I mean, this is a procedure we have now. Until we amend it and change it, and we had some persons in other corridors who say, okay, if you also come, we also take off. I think it wouldn't be good for our democracy. Our democracy, you understand? So for me, we have to look at 146 again as a country.
So you see, I am particularly happy you agree with me that when the Chief Justice becomes the People's Chief Justice, it is only right that we involve the people in his or her suspension. And that calls for the critical look of Article 146. You see, your final words, and I believe we've had a very good conversation. Your final words so that we wrap up the conversation.
Well, so my final words are basically simple. Like we've established here, I'm saying that when it comes to the suspension of the CJ per the topic, I mean, the president has complied with every provision stated in here. There's no clear breach. If there's any, I believe that the right forum was for us to challenge him in court. But
go to court.
2966.
Go to court.
2966. Agbamava has settled it for us. And my final words is that yes, you can law is a re-engineering tool for social justice. So if you see that something it's might be exploited by people, and for the politicians, they always have their day. It's not them.
You are not.
Nkrumah overthrew. He took off.
Akukosa
in the life. Not because he's a good man or a bad man, because the law allowed him to do it. You understand? So until we all come to a conclusion that, okay, this provision, we have to tighten it a bit and take it a bit away from the executive, we'll still be going around circles again. But I think that I'm happy it's happening within this time, whereby Professor Kwesi Prempeh is working on the Constitution. I believe this will be a point that they have to look out for, so that we have a refined process of taking off any CJ if the person, in essence, contravene the provisions of the Constitution or any other law. We want to have a very good independent judiciary whereby they give decisions irrespective of whoever appointed them. And it's even funny that even in the US, there are some judges who campaign on party platforms or party tickets who are elected, but the people still expect them to adjudicate based on the law.
That is the US. That is the US.
Yes, it's also doable. So, sometimes the arguments people make, this was appointed by this, but I don't buy the idea. Even if you are appointed by somebody, at the end of the day, your oath, your fidelity is the Constitution,
to the law,
and to the people who ultimately we are exercising this power to promote their welfare. So if you think about it and you do that, I think it is something that we should. And maybe let me take this opportunity to celebrate the MPP Attorney General 31st December case.
Okay.
Because you remember in that particular case,
we are celebrating the MPP.
The coup.
The lawyer for that case was Peter Alajeti.
Perfect.
Peter Alajeti.
Perfect. And the judges did very well. And I think that should be a semblance of, because it's something that Chairman Rawlings had cherished so much. And coming into 1992, we're not too clear whether what happened in 81, whether he will come back again or not, allow us to go. Then within the week, you see military men marching in the street, getting ready to do their 31st December march, and judges sit and they give the decision and say that this is unconstitutional. They didn't care. They weren't afraid of Chairman Rawlings that something will happen to them. Their fidelity was to the Constitution. So I believe that irrespective of whoever you are appointed, who appoints you, your fidelity should be to the Constitution, to the law, and to the people in whose name you are exercising such a power. So this will be my last words.
Thank you very much, Kisi. It was nice having you, Mr. President.
Thank you.
President. Thank you, guys. This video is proudly sponsored by Vian's Groceries and Nkrumah. Their contact is on the screen. For Vian's, any grocery you want, for Nkrumah, any kind of food you want. If you don't want to get to the kitchen, you have workloads to complete, just contact them. My name is Aaron Asiedu-Antwi, and as I've always been saying, do not leave all your matters to God. Take some to your lawyer. Your lawyer must eat. This has been the Law Lab. Goodbye.